Thank you all for joining us today to talk a little bit more about the fourth edition of the 50 State Labor Report. My name is Elizabeth Stell. I'm the Director of Policy Analysis at Commonwealth Foundation. And very excited to have David Osborne and Andrew Holman, who are two of our labor experts, talk a little bit more in detail about the trends in labor laws across the 50 states, what they found, and hopefully some things you can take away for your work in your state as we continue to see some positive progress on the Janus front, but also some concerning trends developing as well. So it's certainly a mixed bag, but we're really excited to dig into the details with you today. And I'm also joined by Nathan Benefield, our Vice President of Policy Analysis here, and he's going to talk a little bit more about the setting and the context of this report. As I mentioned, we've done it 4 times now. This has been every time, really learned a lot about this issue, not just in Pennsylvania, but the other states. And we really think and hope that this is a resource that all of you can use to do good work in your states. We're going to be answering questions through the Q&A button today. So if you have a question or a comment or something you want to add to the conversation, please type that out in the Q&A box, and we will get to those as we work through the presentation. So we'll start with Nate, and then we'll go to Andrew and David for a presentation on the report, and then we'll go to Q&A from there. So thanks again for joining us, and I'll turn it over to Nate.
Yeah, thanks, Liz. Just to kick it off, I wanted to talk about why we've done this report and why I got started. At Commonwealth Foundation, we realized several years ago that every single issue that we touched and worked on, from education policy, school choice, tax policy, welfare reform, criminal justice reform, one fairly unique to Pennsylvania, but privatizing our state-run liquor stores, which are controlled by the union. In every single case, we are running into public sector unions, and that the challenge that they have and the power they have in large part because of the special privileges given them, even in violation of their own members and over workers, and realizing the importance of this policy, and then realizing that to make advancements on this issue, it is important to talk about what other states have, and our lawmakers here don't like to be the first state to ever do anything. They want to know, what's everyone else doing? Let's do that. And putting together some of this analysis, even the question of how many other states have something like paycheck protection, how many other states have union recertification laws, that information was not readily available. So as we started putting that together for our own internal purposes, wanted to go broader and let's make this available for everyone so that they can see what other states are doing, what progress is being made, and what are the best examples for their states. And so start on this, and now, as Liz mentioned, this is our fourth edition of this, and a few updates and changes in that. But I'll turn it over to David to describe that.
Thanks, Nate. So this is the report here. As you see, it's the 4th edition. It's also a monster compared to the previous reports. It's much longer, and I'll show you why. But before we jumped into a slide deck sharing with you many of our findings, I thought I'd just give you a brief tour of the document itself. So here's the cover page and authors and stuff like that. We've got our key points up front. You're definitely going to make it to that. And then you'll make it to the introduction and part 1, which is a narrative on many of the big legislative changes throughout the country. Sometimes we focus on a particular state. Sometimes it's on a topic that's kind of hot in labor law, like certain laws that are unionizing new sectors within the public workforce. You'll definitely make it to that. What you may not make it to, because your eyes may glaze over, is some really good stuff after that. There's a chart here that gives you a comprehensive look at which states have what laws and what's changed in the last 4 years. You'll see membership as part on membership losses within 4 of the largest public sector unions. We focus just on the national unions, and we use their LM2s to create this table. And then a brief section on some of the impactful litigation that's happened over the past 2 years. After that, we have our grading system and a brief narrative on which states have received what grades. I could have used that on an interview I was doing the other day and couldn't find it. And then a map showing a color version of that. Changes in the last few years since we've started this report. This will show you some major trends. Whether you agree with our grading system or not, you can see some trends form here. And then the next section of the report is a state-by-state public sector labor law profile. So you can zoom down to your state. You'll see the grade over on the side, and then a brief narrative. We wrote this based on what we felt was very interesting over the last couple of years in each state. And we hammered on every single state. There was something interesting to find in absolutely every state. So if you can make it through that, then you get to something that is probably gold for the work that you're doing within your state think tank. It's, boy, I have to zoom down. It's an appendix, a big, giant appendix. Look at that. Landscape format, and in each state it'll give the grade and then answers to some of the questions that we asked in order to assign that grade. So if you're in Arkansas, for instance, you can quickly check to see whether your state has a law like these. The answer is almost always no for Arkansas. But then at the end, you'll get a statutory reference. And by popular demand, we added links to each one of these labor laws. For California, look at all the labor laws that they have. In other states, it's a lot easier. You can click on it and it'll take you immediately to the section in your state statutes where this stuff is located. All right. So once you get down past that, you'll see a brief, you'll see a page here with our contact info. That's it. So I'm going to stop sharing. Let's see if I can figure out how to do that. Stop sharing. All right. So Andrew's going to queue up our slideshow here. And you might as well, Andrew, just go ahead and skip that first one and go to back. Oh, sorry. Go back. I'm at the cover page. All right, so background. You got a little bit of this from Nate, but I wanted to share a couple more items with you. So this is published every 2 years, but we also have two other reports that we've released in this series. One is called How Government Unions Fund Politics Across the Country. We published that in December of 2023. And then another separate report earlier this year called Examining Union Membership in State Government, which we published in March 2024. They all look a little bit of the same because they're all, as far as we see it, in the same series of research, but they focus, of course, on different topics. The first one on union politics and the second one on union membership. As a result, look, this study that we've done focuses on the state's labor laws. We don't pretend to try to take on anything else. To the degree you have questions about government funding politics or union membership, we've touched on that just a little bit in this report, but we hope that you tune in again later on in the year or early next year when we can release these other reports again. Andrew Holman is going to be joining me for this presentation. We're co-authors on this report, and he's done a fantastic job with me on this. In this particular report, we closely examine state laws that, as we see it, strike a balance between empowering union executives on the one hand and empowering the workers that those unions are supposed to be representing on the other, basically A+ to F. We also take a look at national membership trends and major developments in litigation. The value that we're adding to the research in this area that you guys have also been involved in is that we look through the lens of workers instead of union executives and taxpayers, instead of union interests, which is the kind of report you might find from professors or from other worker organizations throughout the country. So why focus on public sector labor law? Again, Nate mentioned some of this. Unions are a major player in policy and politics. Teachers unions and state and local employee unions like SCIU and AFSCME and police and fire unions have really loud voices in state capitals and a profound influence on national elections. At their root, state labor laws are a combination of various legal privileges to unions. These are entities, unions that were once organic, unregulated, and strictly voluntary. But today, state labor laws regulate the process of organizing a particular workforce and bless unions with something called exclusive representation. It's essentially a monopoly right to represent workers in a particular workplace, even workers who voted against the union and don't want to be represented by them. That's just one example of the privileges that unions secure under state law. Unions secure additional privileges, such as the right to strike, to restrict members from resigning their union membership, and to collect dues and PAC contributions to the public payroll system, among many others. And what's important to see here is the immense benefit that these privileges can be in building a union power structure. And of course, as many of you know, once the unions become powerful, the men and women that run them often maintain this power as a means to further their own political celebrity instead of as a means to represent workers. The objective in the report is threefold. We wanted to make labor law more accessible to you, state think tank, people who work in state think tanks, and to others who are interested in public sector labor reform. We wanted to show how simple changes in state labor law can alter the power balance to empower individual employees, even in heavily unionized environments. Florida is a fantastic example of this. We'll go into detail on that later on in the presentation. And then third, we wanted to show the importance of labor law to those who are working in other policy areas. So if you're working on education reform or on taxation, this should matter to you as well. Let's see, some final notes on methodology before we jump into the substance. This report focuses on labor law developments for the last 2 years, and we're looking at a combination of labor laws in every state, then assigning a grade based on a variety of factors. We're largely gauging the level of freedom that is given to individual employees versus the collective. So we're not grading every aspect of state labor law, such as case law, administrative rules and regulations, or the kind of common practices that really do matter for individual employees. Finally, I mentioned when we talk about union membership, we're referring to numbers from LN2 forms that are filed by unions with the U.S. Department of Labor. These are self-reports from the unions, for better or worse. So unions may have understated some of the information they believe is negative. They also may have overstated some positive information for them. But when it comes to membership losses, we felt this was a conservative way to estimate their losses. There may obviously be more accurate measures out there. All right, so Andrew, can you first go over the big key findings that come out of this report?
Yeah, absolutely. Thanks, David. I think one of the biggest takeaways here is the membership loss numbers. We found that the four largest government unions, that's American Federation of Teachers, National Education Association, American Federation of State, County, and Municipal Employees, and Service Employees International Union, those four unions have combined to lose over 320,000 members since the 2018 Janus decision. And these membership losses represent roughly $106.8 million in annual dues. And I think one of the noteworthy things here is that these unions are continuing to lose membership. They've actually lost over 100,000 members since 2022, so in the past 2 years alone. Now, what we're seeing is that union executives are really engaging in aggressive political and organizing campaigns to try and change laws to recruit new members and increase their revenue. In some states, this looks like organizing new employee groups, gaining access to employee information, undoing protections for workers and taxpayers, or in a state like Illinois, it's giving unions an unprecedented amount of power in the collective bargaining process. In this respect, we've seen unions make ground in Illinois, Michigan, and Maryland over the past 2 years. On the other hand, we're seeing some great developments, particularly in Florida, who has really set the new gold standard for what worker and taxpayer-friendly public sector labor reform looks like. And we also saw some victories in Arkansas, Kentucky, and Tennessee with paycheck protection legislation. On the litigation side, Janus-related litigation has narrowed in number, but we're still seeing public public interest law firms successfully defend employees' rights and really keep those unions in check. And we're also seeing them come up with new and creative approaches to litigate on behalf of public sector employees and help them fight back against union overreach. David mentioned a little bit about our grading. In regards to grading, we saw 3 states have significant grade changes. That's Florida going from a C to an A, Michigan going from a B to a D, and Illinois going from a D- to an F. I'm going to talk a little bit about union membership trends. I covered this in the key finding a little bit. I think the interesting takeaway here is the percentages that you see on the table. And what this shows is that AFSCME in particular has been really hard hit by membership losses over the past few years. So monetarily, AFT and SEIU are also taking big hits, but in terms of numbers, AFSCME is really taking the biggest hit out of the 4.
Well, we're going to start with Illinois, because Illinois may set a new standard for F. We saw a very aggressive union policy unfold there since our last report. The reason is that Illinois voters adopted an amendment to the state constitution known as Amendment 1. I'll read just a little bit from the amendment itself, which says it creates a fundamental right to organize and to bargain collectively through representatives of their own choosing, and then makes very clear, quote, no law shall be passed that interferes with, negates, or diminishes the right of employees to organize and bargain collectively. That's really powerful language, and because it's in a state constitutional provision, of course, it naturally, even if it didn't say so, it naturally trumps any other state law to the contrary. There is some ongoing litigation about this topic, and I didn't know about until Illinois Policy Institute, Miley over there, made me aware of it. But even some of the supporters of this amendment, when it was adopted, may actually realize that they've created a monster. But this basically puts anything in a collective bargaining agreement, perhaps anything a union does, beyond the scope of any regulation or any existing law. Meaning that if regulators or lawmakers want to do something about this, they've got to get behind another constitutional amendment to fix it. We've already seen the Chicago Teachers Union take advantage of this. During contract negotiations, they've gone well outside the scope of traditional collective bargaining over wages and benefits, for instance, and have made some really outrageous demands like affordable housing, homeless shelters in all schools, all electric bus fleets, and abortion care funding. All of this stuff could be done by collective bargaining agreement if you've got a sort of a super constitutional amendment like this. We actually did see a number of states try to adopt measures like this. This is probably, if we're talking later about Florida as the gold standard, this is probably the gold standard for public sector union officials.
I'm going to talk a little bit about Michigan now. As I mentioned before, their grade moved from a B to a D. And Michigan really showed over the past 2 years that everything can change in the matter of 2 years. Michigan lawmakers, particularly union-backed lawmakers, completely upended the state's public sector labor laws. They became the first state to legislatively overturn paycheck protection. They began requiring employers to furnish unions with employees' personal contact information, which we'll touch on a little later. And they extended collective bargaining to a bunch of new employee groups. Now, I think what made a lot of headlines in Michigan as well is that they overturned their private sector right to work law. What I think flew under the radar a little bit is a new fair share fee trigger law that essentially states that if Janus is overturned or if the United States Constitution is amended to supersede Janus, Michigan state law will have fair share fees in it. This is something that, in the past you've seen with abortion at the state level, also at the local level with some firearm stuff and housing policy. This is completely new in the realm of public sector labor. And I think that this is something to keep an eye on in the future as things progress, is seeing what other states are going to try this type of legislation out. Also wanted to touch on Maryland. Maryland earned an F grade. Their grade didn't change. But I think what Maryland shows is how public sector union executives are really trying to fill in for some of those membership losses in areas that are already very friendly to them. Our union membership research that we did earlier this year found that Maryland actually already had the highest union membership rate in state government. And what they did here legislatively is they extended bargaining to new employee groups, including state attorneys, public library employees, and supervisory state employees. And they also did stuff like passing a tax deduction for union dues, allowing employees to deduct their dues amount from their state taxes. And I think Maryland really shows that even in the most union-friendly states, there's unions are always going to see opportunities to improve on their membership and their finances. And Maryland's a perfect opportunity of them doing so over the past 2 years.
Good news comes from Florida. We ranked Florida C only a couple of years ago, and it's improved all the way to an A. The reason is that they adopted some really transformative reforms that are going to totally change the way that unions operate in Florida. We've already seen a lot of results from this. One of those reforms is something called recertification, a concept that came from Wisconsin. Perhaps one of the best things that Wisconsin did with Act 10 was introduce this idea of recertification. It's basically a requirement that unions run for re-election periodically if they're going to continue to represent workers in a particular workplace. The reason that that's so transformative is that unions in most states don't have to run for re-election ever. They win certification based on an election, sometimes without an election, and they hold that for decades at a time. In Pennsylvania, we've done some studies that show very few workers who initially voted for the union are still there today. In Philadelphia School District, when we did the study, there was one person left from the 1970 vote, and is a librarian who's probably since retired. Recertification, regardless of how you do it, recertification simply asks employees if they want to retain the union as their certified bargaining agent. In Florida, there's a trigger. If a union's membership falls below 60%, then the union has to stand for re-election. Now, importantly, in a lot of the reporting, some of the reporters are under the impression that a union automatically loses its certification if it falls below 60% membership. That's not it. They stand for re-election, and they could win re-election with a majority, even people who aren't members of the union, if the employees believe that they would do a good job as their union representative. So that's one measure that came through in Florida. They also enacted a paycheck protection in which the government does not have to collect unions' dues or fees for employees or PAC dollars. And then the third one that was interesting to me, there are a few others we could talk about, but the third one that's interesting to me is the requirement that unions make a great deal of disclosures to the equivalent of the state labor board in Florida. They have to turn over financial documents to the state, along with auditors' review of those documents, including membership numbers. So one of the problems with their recertification law in years past has been that it's based on union self-reporting. This law should fix that and allow and require an auditor to look over those numbers before they're given over to the Florida government. So all in all, I guess the one takeaway from Florida, if the takeaway from Michigan is that you have to keep your anything can happen within the span of a couple of years. You could lose some very good reforms very quickly. Florida, I think, demonstrates that in order to keep your very good reforms, once you have them, put your foot on the gas pedal. Florida has already done some major legislation over the past couple of years, but then over the past decade, but now over the last couple of years, they've really doubled down and improved even further on. That takes them from a C to an A. All right, and then so those are some of the states that we covered. We also covered a few of the major trends in labor legislation over the past couple of years. Paycheck protection, not a terribly new concept, but paycheck protection has really taken off over the past few years. I think it's very attractive to legislators. Arkansas, Kentucky, and Tennessee over the past couple of years all enacted a version of paycheck protection in their state. The basics is that this legislation makes unions responsible for collecting their own money. And there's a U.S. Supreme Court case called YSURSA. It's YSURSA versus Pocatello Education Association back in 2009 that confirmed that states have no responsibility constitutionally to subsidize union political activity by collecting union money. That makes this kind of legislation, I think, really easy to introduce to legislators and really easy to defend. Politically, of course, it's still going to draw the ire of the unions. They're still going to say it's the end of the world, but it's a simple reform in the end that protects public employees. And then I'd argue focuses union executives on proving their value to members. If they can simply collect dues without members ever having to see it, I think that allows them to skate by. If it comes out of people's bank accounts and they can actually see the amount that's leaving their bank account, I think that puts the onus on union executives to really prove their value.
I'm going to touch on a few other notable trends. First off, we've seen that an increasing number of states are pursuing legislation that requires public employers to give unions employees personal contact information. We've seen this in 14 states since the Janus decision. And this can involve things like a employee's home address, personal cell phone number, personal email address. And in some cases, I believe in Hawaii and Vermont, it's much larger and can encompass things such as social security numbers. Now, obviously, with this, you have the issues of unwanted solicitations where unions are sending political mailers and other organizing materials to employees' houses. But this type of legislation, especially with the sensitive information, opens up a whole nother set of issues where there's really no guarantee that the union is going to handle this information responsibly. And in one such instance in California, we saw one of the SEIU locals fall victim to a cyber attack, and cyber criminals got their hands on the personal information of thousands of public employees. So not only is this type of legislation annoying to employees who don't want to receive political mailers and other stuff from their unions, it can also be dangerous to the point where it's opening them up to identity theft. Secondly, we also saw tax incentives for union dues becoming far more widespread, with 3 states over the past 2 years, California, Delaware, and Maryland, enacting these benefits. Each state kind of takes a bit of a different approach. I think Delaware has the mildest approach, where they offer a tax deduction that's capped at $500. Maryland also offers a tax deduction that's not capped, whereas California, they actually offer a tax credit, which is a far bigger benefit. They appropriated about $400 million worth, and it wasn't capped in the legislation, but I believe they decided on about 33% of dues are able to be claimed for that tax credit. Obviously, that is a massive benefit, and this is something these 3 states did it over the past 2 years. It's already spread into new states. Michigan, in fact, had a proposal that proposed a unlimited refundable tax credit for union dues, to the point where if your state tax bill was less than your union dues, the state would actually cut you a check for the difference there. Thankfully, that one hasn't passed, but I think this is something that you're going to have to be on guard for in the coming years as it becomes more popular. Finally, we're seeing that in union strongholds, lawmakers are constantly working to extend bargaining privileges to new groups of employees. Some common targets are legislative staff, public university student workers, supervisory employees in state governments, things like public library employees, school administrators, the whole 9 yards. We're also seeing unions continuously working to overturn restrictions on public sector bargaining, such as introducing bargaining in a state like Georgia or North Carolina, extending it to more groups in Texas, or trying to build on what they did a few years ago in Virginia by extending it to state employees. Finally, some good news outside of Florida. We're seeing 4 states that introduced legislation that would provide for regular recertification elections. This is a wide range of states, including Connecticut, Louisiana, Pennsylvania, and Utah. 3 states already have this: Wisconsin, Iowa, and Florida. And I think, particularly with Florida, some of the successes of this have been highlighted. And I think this is a positive development that I hope to see more states undertaking in the coming years.
We had a brief note in the report about litigation, and we have been tracking litigation involving public sector labor employees and labor unions. Sort of 2 broad categories. One has to do with the U.S. Supreme Court case in Janus. In 2018, the Supreme Court in the Janus versus AFSCME case determined that public employees should not have to pay dues or fees as a condition of their employment. Well, those were important rights that were enunciated by the U.S. Supreme Court, but they weren't self-enforcing. So what it really took after that was a number of public interest law firms across the country litigating cases against unions to ensure that unions followed the rule of law in Janus. And I have to say, in a lot of ways, it was a surprising victory against labor unions. I thought that they would have been far more successful in evading some of Janus. Now they're still doing it. So whether it's enforcing Janus or some of the workarounds, there are a lot of cases filed. We counted 218 since Janus that sought to keep union executives in check. And I find these very important cases. You might call them enforcement cases. They're not necessarily precedent setting. Sometimes all they're doing is requiring the union give back the fees that they unlawfully took from union members. But I think they help keep union executives in check. Absolutely necessary. Many of them are coming to a close. So we are seeing some of them be dismissed or settled over the past few years. And there are fewer by far now than there were immediately after Janus. The second category is, I'd say, cases that could have been filed with or without Janus. Some of them are new and creative approaches to protecting public sector employees that I didn't think of until I saw them filed. One is, so I'll give a few examples here with some brief discussion on each. One big victory recently for the Goldwater Institute in Arizona was a case called Gilmore versus Gallego. Goldwater's really pioneered the idea of going after something called union release time. They've done it for years. I stole it when we filed a case. Union release time is the idea that you can take a public employee, have them work full-time for the union while still receiving all of the benefits and salary of a public sector employee. This is a big problem in a lot of governments, certainly in our federal government. This kind of arrangement in our federal government basically keeps unions alive and in business. While the Arizona Supreme Court just recently decided that union release time, at least in one occasion, but I think this probably applies to any form of union release time in Arizona, is unconstitutional as a violation of the state's gift clause. There's a clause in the Constitution, the state constitution, that prevents the government from basically giving over public goods or public money to a private organization without receiving something in return. And that's basically union release time. The government is allowing government employees to go work full-time for a union without really receiving anything in exchange for it. Big victory in Arizona, and hopefully there are Supreme Court in other states that might take heart by this kind of an opinion in Arizona. Second one here is a case called McFetridge versus AFSCME Council 13, brought by an organization called the Fairness Center out of Pennsylvania. It's a case involving the duty of fair representation. The duty of fair representation is basically a fiduciary duty that unions owe to their members. And whenever a union does something that say is in bad faith, is unreasonable or arbitrary, they technically violate that duty of fair representation. So this was a case filed over union policies related to that the union member felt violated her rights as an employee specifically discriminated against her on the basis of her sex, and she went after the union on that basis. Second one is one that just concluded, third one here is the one that was just concluded, Newman versus Elk Grove Education Association. Also a Fairness Center case. Fairness Center went after the union in California on the basis that it had violated Title VII of the Civil Rights Act, something we often see applied to employers. Well, technically, a union is also under federal law defined as an employer for purposes of Title VII. So cases can be filed against them whenever they do something that is discriminatory in nature. And then the fourth one here is one that's on cert to the U.S. Supreme Court. It's a National Right to Work case and Fairness Center case called Goldstein versus Professional Staff Congress. This challenges the very idea of exclusive representation, the idea that a union has the right to represent people who had no say in whether they represented them and who may even actively resent the fact that their union represents them. In this particular case, it's a union that is rabidly anti-Semitic, and a number of public sector employees who happen to be three of four of whom happen to be Jewish and who resent the union for having the authority to represent them as a exclusive representative.
Just to wrap things up, I think, in conclusion, we're seeing that the fight over public sector labor law is not over. There's still a lot of work to be done. Unions are, continuing to respond to Janus by waging aggressive political and organizing campaigns to expand or further entrench the powers that they hold. As I mentioned earlier, in some states, this is rolling back worker protections. In other, it's expanding collective bargaining or granting unprecedented power at the bargaining table. We're also still seeing some great successes. Florida has really set the new gold standard as they do their work on recertification, paycheck protection, and other reforms that have proven to be effective. And I really want to emphasize that the importance of public sector labor law. As Nate mentioned earlier, unions touch every area of public policy, and state laws really do determine the extent of the influence that they hold. And I think Florida and Illinois are great examples of this. In Florida, where the union influence is limited and they continue to push back against it, there's low taxes, the economy is booming, it's one of the fastest growing states. And in contrast, you have Illinois, where there's high taxes, bloated budgets. People are constantly leaving the state, and they grant significant powers to public sector unions. And it's no coincidence that this is the case. So, as time progresses and we continue to work through Push Janus, I think that there's you're going to see a lot of opportunities in the public sector labor law sphere, and I think you're going to start seeing states kind of polarize a little bit, where the worker-friendly states are going to continue to get more worker-friendly, and the union-friendly states are going to continue to get more union-friendly.
Just want to remind everyone that if they do have questions or points they want to raise, there is a Q&A function, a button on the bottom of your screen. Click that, type in your question or your comment, and we'll make sure to get to that as we wrap up here. So Andrew and David, before we go to questions and discussion, could you talk a little bit about the interactive tool that folks can also use to make maybe that monster of report a little more digestible?
Absolutely. I can pull it up on my screen here in 1 second.
I put the link in the chat if folks would like to follow along on their own.
So we have this great online tool. There's a link to the report here. It brings up a map. If you click on a state, say Pennsylvania, it'll give you their grade and some of the top line information. Are strikes legal? Is it a right to work state? Is there paycheck protection? And then you can also do a deep dive into that state, where it'll essentially show you a version of the appendix where you can see all of the things that the state is graded on. And one of the really cool things is then you can compare the states. So say compare Pennsylvania to Illinois, and then those two states with Florida. you can see right across the line, some of the differences, and it makes it really, really easy, and very accessible. The information is very accessible.
Thanks, Andrew. So I have a couple questions to get us started. And this is for anyone who would like to jump in here. But I think, one of the big questions that I always get, and I'm always thinking about when we're talking about good labor reform and labor reform in the states is, how do you convince your lawmakers or influential folks in the state where these issues are not controversial? You don't have huge union funded PACs that are really influencing the policymaking process in the same way that we have in some states like Illinois and Pennsylvania. So how do you sell your leaders on working and creating some of these good laws that you mentioned in David, like in Florida, they had some good laws in the books and they just kept building on them. But how do you really how would you persuade the lawmakers to address these issues if they're not hot topics currently?
Well, I may have had trouble answering that question a few years ago, but when I was working on this report, it made me aware that even in these kinds of states you're talking about, Liz, states where it seems like unions aren't a problem, unions are working very hard to become a problem. So in the state by state section, we look at a few of those. I had no idea, for instance, that unions in North Carolina were coming closer and closer to getting some collective bargaining laws passed there and overturning what used to be the least union friendly state in the country. So I think that's an awareness that unions are building something there. But then second, I think it's important to look across the pond at other states where things are not going well and to clearly identify the source of those problems as the unions. So in West Virginia, for instance, where things appear to be getting a little bit better, they can look across and see that Pennsylvania is having issues with unions that prevent good things from happening, like school choice. And then maybe finally, you can look at states like Florida. West Virginia is actually still a good example. States where reforms have been enacted recently, and these reforms have not been election killers. In fact, they've been extremely helpful. They've taken some of the biggest special interests and put them back on a level playing field with others, so that in my view, good policy reform is also really good politics. Andrew, would you add anything to that?
Yeah, I think one of the most interesting things to me is what we saw with the paycheck protection legislation in, I believe it was Arkansas and Kentucky, where the legislation was actually coupled or came right on the heels of a big significant raise to teacher pay. And I think that's a perfect example of these policies. They're not anti-worker, they're pro-worker. They want to help employees, and all they want to do is just take the union influence out of stuff and remove those special privileges that the unions enjoy.
That's a good point. DeSantis did that too in Florida. He originally packaged these measures as a component of something called the Teachers' Bill of Rights, and most of them were focused more on overtly improving the lives of teachers. This could be sold as equally as important as a teacher pay raise.
Yeah, and I think some of the good reforms in this space have been packages with teacher pay raises, which is a whole other topic. Which I guess we could go down in terms of how are union members actually faring when it comes to their compensation. And you would think, if the union is really strong, the union members would be doing really well, and that isn't necessarily the case. But I digress. So we have a question for the panel. Philosophically, we oppose public sector collective bargaining for all public employees. Politically, excluding police and fire is a non-starter. Your emergency unions. So how have reforms that exclude public safety employees been sold successfully to legislators? I know this is a common challenge that we face when we're trying to implement good reform.
Yeah, I think I think there are actually two different answers. One is how is it sold to legislators? Legislators will understand the political calculus. They'll understand that if police and fire unions think that something's a threat, they're going to march in guys in uniform to sit down at the legislative hearing, and they're going to ruin everything for you. So legislators will understand this. They'll also understand the fact that some of the money for people who might believe in pro-worker legislation may actually be coming from police and fire unions who are expecting something from them. It's ugly, but it's true. I think they'll get it. What's a little bit more, perhaps more important, is how do you sell it ultimately to the courts? There have been a number of lawsuits over this kind of distinction between regular old public sector employees like teachers and state and county workers and cops and firefighters. They've been successful, at least for a period, but in most courts, this has not been a valid claim. The claim is equal protection. The unions will file a lawsuit and say, if you do this kind of reform for one union, you have to have a reasonable, a rational reason why you would do it. You wouldn't do it to another union. So, but this has failed in most cases. I think it worked in Missouri, but in most states, this kind of claim has been denied. Most importantly, in federal court, it's been denied a number of times. The thing that seems to work across the board is an explanation like, look, there are two separate codes here, two separate laws. We're going to tackle one before we tackle the other. Or in Florida, where this is still under litigation, there are not actually two different codes or two different laws at issue. They just simply say, look, we wanted to tackle one and not the other. There's nothing to stop us from regulating one set of workers versus another. The problem you might have, which DeSantis has made for himself, is you may have some discussions on the campaign trail where you say you're going to go after teachers unions. Maybe a problem, hopefully you get a smart judge who can see that that's part of politics.
Thanks. That was really helpful. Another question. Have you seen any progress, and again, for anyone on the panel, have you seen any progress toward a strategy to challenge opt-out schemes? This idea, I think the question Nair is driving at this idea of limiting when folks can opt out. So what's going on that front? I know that was a little more predominant in the last report we did, but still a major issue.
Andrew, you want to take that one?
Yeah, I mean, in terms of the opt-out stuff, I think the biggest success, and we saw this in Florida, is actually recognizing the right to resign union membership at any time in state law. And doing that is, that's going to end any opt-out restrictions that exist because employees have that right recognized.
I'll add, maybe this is part of what the question's about, was in litigation. This has been the subject of a lot of challenges in court. Unions seem to find their way out of it, but there are two really good decisions from a ways back, one out of Pennsylvania and one out of California, that holds that these kind of opt-out restrictions are unconstitutional. They were both preliminary injunction decisions, so they were not on the merits. But I think unions understand that this is also unconstitutional, and as soon as you call them on it and sue, they're going to try to weasel their way out of it. The only approach that I've seen work is what the Fairness Center has done in Pennsylvania. They've sued relentlessly over the same thing over and over, and eventually the unions and the governor even got to the point where they realized, look, we're going to make bad law if we continue to put this in our collective bargaining agreements. So they ended up removing them from all the collective bargaining agreements or agreeing not to enforce them.
Great. Another question, you mentioned a couple of different concerning trends, the tax credits for union dues, expanding collective bargaining by unionizing, not CBAs, unionizing new groups of workers that maybe have not been unionized in the past, to try to address some of the challenges financially and also just, decline in membership overall. But what are the things that you're most concerned about that maybe aren't necessarily the flashiest items, but you think are the biggest threats in terms of worker freedom right now? So, what would you really encourage states to hone in on here in the next 2 years?
We might both have different answers to this. And I'll go first. One of the things that this is a little older than 2 years now, but Virginia made a huge political compromise. They were one of the states that for a very long time had prohibited collective bargaining in the public sector. And there were some very strong pushes for public sector unionism within their state, the kind that at least we on the call are used to, the kind where the state oversees public sector unionization. They have a state labor board. They have unfair labor practices. They have a statutory scheme. Well, Virginia came really close to adopting something like that. Its Republicans really waffled on the idea that, well, we don't have to create that, but we could give local governments the option to create that for themselves. And they took to that. It also was virtually cost-free for the state. So they pushed down all the costs of collective bargaining on the local level. And as a result, many of the local governments in Virginia are now having to wrestle with the question of whether they should adopt public sector bargaining. It gave union officials a foot in the door, obviously in places like Loudoun and Fairfax, where unionization had essentially happened on an unregulated basis already. But it makes it easier for collective bargaining to work its way all across the state. I would not be surprised. Now, it hasn't been as easy as unions thought it would be to capture some of these other locations, but it obviously diverts the attention of local government officials. It gives unions a foot in the door, and it gives them the authority that they didn't have before to demand new laws at the state level. I would not be surprised if it's just a step on the way to full-scale unionization of the public sector in Virginia. And I've been worried that that's going to happen in other states where things have gone pretty well over the past few years. Andrew, how about you?
Yeah, I think the biggest threat for me is the Illinois style constitutional amendment. Upon first look at it, first read, it doesn't really seem that bad. It seems like you're just kind of recognizing the right to collective bargain. But then, really digging into some of the language, especially the fundamental right to collective bargaining, and understanding the implications of that, where bargaining agreements are going to be trumping state law. I think, that it's a real problem. And I think the way it's written and the way it's framed isn't as apparent that it's such a big problem. Like, the tax credit for union dues, that on its face, it's very clear that's a taxpayer subsidy for union activity. That's bad. I think something like this, especially they tried it in Pennsylvania, a state like Pennsylvania that's, already somewhat union friendly. You might read it and think, oh, what's the big deal? It's just recognizing the right to collective bargaining. It's going a lot deeper than that. And you're already seeing it in other states. I know they tried it in Pennsylvania. They tried it in California. It passed in Vermont, not enacted, but it went through the first step of the constitutional amendment process. And I think they're trying it in Minnesota as well. So I think that's a big threat to be on the lookout for.
Thanks, Andrew. I'm going to ask you one more call for questions or comments here as we come to the end of our time. And speaking to that broader question of why should you work on this issue? Why does it matter? I'm going to throw something in the chat. It's a recent op-ed that David co-authored. I think really gets to the heart of why these issues touch every other issue that we work on and care about at the state level. And if you do want our help in looking at the labor laws in your state or writing something for the media or making the case to lawmakers, we want to be a resource to you. We want to help you make that case and figure out the best course of action in your state, because the opportunities are going to look different in every place in the country. And hopefully this report, with the state summaries, with the comparison tools, will really help you key in on what you can do to move the ball forward and set your state up for success, the way that we've seen states embrace worker freedom and succeed on scores of measures, in part because of it. So in closing, Nate, I'll just kind of hand it off to you and ask you to bring us home by talking about what you see as the major opportunities going from here where we're at in 2024, and talking about the broader context of why we need to keep doing this work. Nate, did you have any closing thoughts?
Yeah, just, I think the continued importance of, how important, I think what the report shows is the progress that has been made, but continues to be that the influence of public sector unions in our policymaking, in our lives and in our states. And you can see the progress, I think, states like Florida have made, and seeing what's happening there versus what is happening in states like Illinois and California. And it's not just, hey, look at the labor laws and the grade of A versus an F. That's where population is leaving, and leaving states like Illinois and California, New York, and moving to states like Florida and Texas that have scored wellness. So the connection between the labor policies and the economy and the economic policies that states are enacting is huge and critical, and seeing this as should be a priority for everyone in all the states. And I think, as David alluded to, even those states that currently are doing well, unions are making efforts to make inroads and get those privileges on the books to empower them in those states. So even those states need to be on the defensive.
Thanks, Nate. Thank you all for joining us. If you have follow-up questions, we're happy to field those for you. And we will definitely be sharing with you our new labor research as we roll it out through 2025. But please don't hesitate to reach out if you want some advice, want to collaborate. We hope that this tool will be really useful to you, all the different components of it. And we really appreciate your time. And thank you for joining us today. And there will be a recording of this. Last thing I need to note. So if you have colleagues or friends that would like to hear the webinar, but we're not able to make it today, we will make that recording available to you as well. Thanks again, everyone, for joining us.